Justice Gorsuch.
What's at stake in allowing state courts to proceed in the ordinary course, as you're talking about?
The stake is that you preserve, one, the state's traditional authority to adjudicate tort claims. Preemption is a big deal. That's why we don't just assume preemption willy-nilly, and there are rules that make clear that preemption applies when certain clear statements are made. Now, I agree Garmin goes further, but it still respects the fact that state courts have an overriding interest in adjudicating state tort claims. The second stake is the plaintiff's right to petition the courts. Frankly, we'd prefer not to be before an administrative agency where the agency is the judge, jury, and executioner. We prefer to be in a court system where we have a neutral judge and the potential for a jury. And so that's why it also protects, as Bill Johnson's also made clear, the plaintiff's right to petition the courts for redress.
What do you say to the argument that the NLRB has a lot of expertise in this area and does see a lot more of these cases than a state court?
And that's precisely the work, I think, that the arguable protection prong does. If the facts show that the facts are arguably protected by the statute, then unless the local interest exception applies, it is the board that gets to decide whether it's not just arguable protection, but it's actual protection. But the board's interest in ensuring that legal uniformity isn't enough, in my view, to override the state's traditional interest in adjudicating tort claims up until the point where it becomes clear that on the actual facts, there's either an arguable or an actual conflict with federal law. Again, it's how preemption generally works, and while the board does have strong interests here, federal agencies have strong interests in a lot of different areas, yet we don't do a wholesale overturning of how federal preemption works in those other areas.
You keep talking about how federal preemption normally works, suggesting Garmin's a bit of an outlier, and we've been struggling this morning with understanding just how far its penumbras extend. I think that was out of Garmin itself. Does it extend so far as to require a hiatus of a state court proceeding even when the pleadings are arguably outside of the statute? And I guess I'm wondering, do you still pursue the suggestion that we ought to rethink Garmin?
Your Honor, we don't think that in order to resolve this case in favor of our client, you have to revisit Garmin. But what I am quite confident on is that you can either interpret Garmin as it stands as being a huge departure from ordinary principles or a medium departure from ordinary principles. Right now, I think it's a medium departure from ordinary principles. If you take it the step that my friends on the other side are suggesting and say that state courts are actually ousted of the authority to make that basic factual determination of whether the facts do, in fact, arguably conflict with the law, then you're turning it into a huge departure.
So it's a medium penumbra, not a huge penumbra.
Your words, Your Honor, or the court's words.
Thank you.